black boy go out with 3 white kids come back, there's a blurred story on what happened, now y'all all hostile and all upset, didn't have the keys, but then you had the keys. Some about this don't make sense given your history. I want to put a reward up for $50,000 for any...
The dispute surrounding Nolan Wells' disappearance has moved toward a possible defamation lawsuit against Al Sharpton. Attorneys representing Warren Hudson, Jax Pitalo, and Morgan Seymour reportedly sent Sharpton a 19-page pre-suit demand letter. They demanded a public apology, a written retraction, correction or deletion of the disputed statements, and preservation of evidence for possible litigation.
We'll put the link in the description section. I want to see you there in September. Al Sharpton has barked himself up the wrong tree. There is a lawsuit and a pursuit of a lawsuit against him for defamation against Warren, Jax, and Morgan. And I don't want to hear none of y'all say that they just asking questions. No, they have put out false information with no evidence against these young boys.
This is not yet a confirmed lawsuit. A pre-suit demand presents one side's allegations and gives the recipient an opportunity to respond before a formal complaint is filed. It does not establish that defamation occurred, and it does not mean a court has accepted either side's account.
We have the lawsuit. We got the whole entire lawsuit. I don't know if we have it ready for people to view the entire. How many pages is it, Grant?
19 pages.
It's 19 pages long. I'm not going to read all the 19 pages. I'm going to give you a summation of them. Do we have the link for them to actually go and look at all 19 pages?
Not quite yet. We're trying to figure out how to do that appropriately.
By the end of the live stream, we should have a link for you. If you want to go look at the entire document as it is.
The dispute centers on public comments Sharpton made about Nolan's cell phone, his keys, and the circumstances surrounding the claim that Nolan chose not to leave Horn Island. Sharpton reportedly questioned whether the explanations about the phone and keys had changed and suggested that the circumstances required further scrutiny.
Another element of what was lied about by Al Sharpton.
I don't know what happened, but I got your history in Mississippi. And the history tells me black boy go out with 3 white kids come back, there's a blurred story on what happened, now y'all all hostile and all upset, didn't have the keys, but then you had the keys. Some about this don't make sense given your history. And I'm gonna stay on this until we find out what happened. It may be nothing, but we're not gonna leave that up to chance with people that are distorted. We gonna stay on this case.
The attorneys for Warren, Jax, and Morgan argue that those comments implied their clients were involved in Nolan's disappearance or had participated in a cover-up. According to the demand letter's summary, they said Sharpton's statements suggested possible evidence tampering or other criminal conduct.
And the defamation claims are centered around, and some of the claims are centered around a cell phone. And here's the controversy. This is what is quoted in the document. It says that you lied about where or whether or not you had the cell phone and the keys. And three, everything's erased from the cell phone. And so the allegation is that Al Sharpton had made lies and claims against the boys that they had deleted things from the cell phone, that they hid the keys, and that things were erased from the cell phone. The letter says that Sharpton implied a cover-up. Attorneys argue that this point pointed directly at Warren, Jax, and Morgan. They said that the claim suggested crimes like evidence tampering or worse. Next clip. The letter says that they never touched the cell phone.
The attorneys denied those implications. They claimed that the 3 young men never possessed, accessed, erased, altered, or tampered with Nolan's cell phone. They also denied that the men concealed his keys or lied about what had happened to them.
In the letter, here are the things that they're contesting that Al Sharpton said, and here are the claims that were made. They did not possess, access, breach, erase, or tamper with Nolan Wells' cell phone. They did not lie about the phone or keys, did come forth and contact family, Coast Guard, and law enforcement. Here's another element.
Those claims were presented by the men's attorneys. The supplied material does not include an independent forensic report establishing whether information was deleted from Nolan's phone, when any deletion occurred, or who may have accessed the device.
Because according to the document in the suit, they're saying that it was not just 3 boys with Nolan alone. That was a lie. There was 30 people traveling together on 3 boats. The letter says that Nolan was not on the same boat as Warren, Jax, or Morgan going out to the island. It claims roughly 2,000 people were on Horn Island that day, and in quote, at no time were they alone.
The size and composition of the group on Horn Island is another disputed issue. According to the attorney's account, Nolan was part of a much larger gathering rather than being alone with 3 friends. They claimed that approximately 30 people traveled together on 3 boats and that Warren, Jax, and Morgan were never alone with Nolan. The source material also referred to an estimate that roughly 2,000 people were present on Horn Island, although no independent attendance record was provided.
Warren has made a statement on my interview, and he's also made an official statement through his lawyers that at 3 p.m., Warren says that he saw Nolan alive and well. That was the last time he saw Nolan with his physical eyes. At 4:28, 27 people departed without Nolan. The letter says that Nolan chose to remain with a young woman at the island, which is verified through text messages, verified through other people who all bear witness to them telling Nolan to get on a boat, and he never did. Here's a statement.
The attorney's timeline states that Warren last saw Nolan alive at approximately 300 p.m. The demand letter reportedly says Nolan remained on the island with a young woman while others prepared to leave. At about 4,027 or 428 p.m., members of the boating group allegedly departed without him.
Here's a statement from them. Go back. At the very bottom of this, it says Nolan chose of his own free will and accord to stay on the island and return home later. All right, next slide. This is Warren's call. This is that Warren had called Nolan's mother and Coast Guard. And here's
according to the attorneys, Nolan chose to remain on the island and planned to return home later. They said text messages and statements from other people supported that account and indicated that Nolan had been encouraged to board the boat, but did not do so.
Crump is next. But here's some of the synopsis of what it entails, and we put it in a pretty little document for you. And it says, and this is quote, unless you comply with the demands set forward in this letter, we will imminently be filing suit against you. Public apology, written retraction is what they're asking for, delete or correction the disputed statements, and preserve evidence for litigation. Next slide. And
that remains the attorney's version of events, not an independently established conclusion about Nolan's intentions. The supplied material does not provide enough authenticated evidence to determine exactly why Nolan stayed or what happened after the boats left.
But anyway, here is phone calls, phone records of a timeline. It says at 11:07 p.m., Warren called Christine Wells. At 11:13, he called the Coast Guard. At 12:25, spoke with the Coast Guard again, this is Warren. And at 1 a.m., Christine called Warren. Sheriff's Department contact followed. So Christine called Warren at 1 a.m. Sheriff's Department contact followed. So that means that he then contacted the Sheriff's Department, the Sheriff's Department was contacted after the phone call with Christine and Warren at 1 a.m. It says to count 2 calls to Christine and 2 times speaking to the Coast Guard. All right, let's go to Al Sharpton.
The source discussion also presented a timeline of communications made after Nolan failed to return. It stated that Warren called Nolan's mother at approximately 11:07 p.m., contacted the Coast Guard at 11:13 p.m., spoke with the Coast Guard again around 12:25 a.m., and that Nolan's mother contacted Warren at approximately 1:00 a.m. Contact involving the sheriff's department reportedly followed.
All right, let's go to Al Sharpton intent to sue letter. Okay, this is just the meat and potatoes of what this is all about. This is the lawyers that are representing Warren, Jax, and Morgan. Okay, this is the most important part of it. You can read the rest on your own if you so desire. It says the letter threatens, and this is our synopsis of the letter, so you don't have to read it if you don't want to. It says the letter threatens a defamation suit against Al Sharpton. It says that Sharpton falsely implied that Warren, Jax, and Morgan were involved. The dispute centered on Nolan's phone, keys, and alleged deleted data. The letter claims that 3 young men never touched or accessed Nolan's phone. It says that Nolan stayed on Horn Island by choice when the larger group left. The letter says Warren contacted Nolan's mother, the Coast Guard, and law enforcement that night. It claims a large group went to the island and that thousands of people were there present, and it wasn't just a few people. The demand is an apology, a retraction, delete statements, and preserve evidence. So if you haven't watched it or you haven't looked at it, here's the summation of it. A link to Sarah Field's image of the letter is up on our Substack. So we put the link to the Substack in the description section. You click that, and we'll give you a quick synopsis again, just in case you want to share it, and then we'll link it to the actual documentation.
And how
The reference transcript did not reproduce authenticated telephone records or provide an official law enforcement confirmation of every detail in that sequence. As a result, the timeline should be understood as information presented in the source material and attributed to the people defending the 3 young men.
And how confident are you? Because you just met these young men more recently. And are you confident that these young men had nothing to do with it?
Confidence not a strong enough word. In fact, beyond a reasonable doubt is not strong enough. There's a 0% chance that they did anything wrong. So this is not 90%, it's not 99%, it's not 99.9999. There's no decimals, there's no anything. It's 100%, 100.000%, nothing. They did nothing wrong, and that's the problem for our opponents.
Officer Brandon Tatum strongly defended Warren, Jax, and Morgan, stating that there was a 100% chance they had done anything wrong. That was Tatum's opinion. It was not a forensic conclusion, investigative finding, judicial ruling, or verdict. His confidence does not legally establish innocence, just as public suspicion does not establish guilt.
For our opponents here, who have ruined their lives, dragged them through the mud, and attacked them. You don't get to lie. We have a First Amendment. We love our First Amendment, but you don't get to lie and hurt people. You want to lie and it doesn't hurt people? Fine. You lie and you hurt people, that's why we have defamation. And that's what this is about. So I just want to emphasize this in the strongest possible terms. Zero wrong.
The threatened legal action now presents 2 opposing positions. The attorneys for Warren, Jax, and Morgan argue that Sharpton turned unresolved questions into damaging implications of criminal conduct. Sharpton's reported comments focused on what he viewed as inconsistencies involving Nolan's belongings, the group's movements, and the account of what happened on the island. Whether Sharpton's statements could support a defamation claim would depend on their exact wording, context, meaning, identifiable targets, and other legal considerations. The demand letter alone does not resolve that question, nor does it establish what happened to Nolan after the boats departed. For now, the dispute remains at the pre-litigation stage. The supplied material contains no court finding that Sharpton defamed anyone and no official determination connecting Warren, Jax, or Morgan to wrongdoing. The letter may lead to litigation, but the central questions surrounding Nolan's final hours, cell phone, keys, and movements on Horn Island remain unresolved.